in his word.
Quite right.
David Clendon.
Thank you, Mr Speaker. Could I just begin my comments by noting the remarks of my colleague Kennedy Graham, who sat on this committee for much of the work that led to this interim report. Just to note his comments to the effect that the committee worked well, it was well chaired, and despite the rather unfortunate task they were given and the constraints laid upon them, they have delivered a useful document, and my colleague looks forward to participating in the work that leads to a final report next year. So this interim report reflects a bizarre episode in our parliamentary history, an episode that reflects well on no one who was involved, and the best we can do is to put in place arrangements to endeavour to ensure there is no repetition of this. So the origin of the whole debacle, of course, lies in the illegal self-empowerment by the GCSB, which came to light more or less by accident and required the Kitteridge inquiry. That Kitteridge report, as we know now, was leaked. The Prime Minister then ordered another inquiry to identify the leaker. The Henry inquiry failed to do that, but racked up an extraordinary series of errors that, in the words of one commentator, would not be out of place in the script of a Dad's Army episode. So the committee's work was initiated, or the catalyst for that rather, was a complaint from our Green co-leader, Dr Russell Norman. The Speaker, in his wisdom, chose not to accept it as a complaint, but referred it instead as a general question of privilege. The result was almost always going to be unsatisfactory by definition. The committee was not given the task of finding who leaked the Kitteridge report, so the public, to a large extent, is none the wiser as to the facts of the case. What we have learned, with some clarity, is more to do with the dangers of taking constitutional principles for granted, because this interim report does highlight some gaps in our practice in that sense. It's when things go wrong that we regret the lack of clear constitutional guidelines. We are one of the very few countries in the world that does not have a written constitution, and it's probably fair to say we have the least developed mechanisms to compensate for that lack of a written document, a written constitution. So the mistakes of the Henry inquiry were largely those of individuals, excessive zeal in one case, a relative indifference from the inquiry leadership to procedural practice, and an emerging cult that seems to treat directives from the PM's office as some form of holy writ which must be obeyed. So these kinds of problems can be neutralised by constitutional protection, and without it they can be exacerbated, even run amok. And that is the primary lesson of the Henry inquiry. We shed no tears for ministerial resignations throughout this episode, but we do have considerable sympathy for the Parliamentary Services resignations, for they were the product of actions against better judgment, under duress from the executive, and a diligent and well-intentioned officials ought never to be put under that sort of pressure, should never be subjected to that, and there should have been protections in place against it. The interim report accurately critiques the shortcomings of the whole sorry affair, and the Green Party endorses this critique. The main test will be the remedial measures recommended in the final report. In terms of the process to date, the Green Party is dissatisfied with the decision by the committee not to have the Prime Minister or the Speaker appear before it. As Minister responsible for GCSB, Mr Key initiated the inquiry, he appointed the co-commissioners, he was consulted over the terms of reference and the choice of inquirer, and publicly released the report. He acknowledges ministerial responsibility for the inquiry. He formed the apex of the executive branch of government in this whole exercise. For his part, the Speaker, being responsible for parliamentary services, formed the apex of the legislative branch in this matter. He too bears responsibility for certain aspects of the inquiry. It is difficult to see how the Privilege Committee, exploring the shortcomings of an inquiry in which two members of Parliament who bore primary responsibility for it did not testify, can perform the job entrusted to it, with some irony, by the Speaker. Then there are the findings of fact. The evidence gathered in the hearings has revealed a series of avoidable errors, political or procedural, by virtually every individual who is directly involved in the key inquiry. Firstly, the Prime Minister decides a ministerial inquiry should be set up, appointed the co-commissioner, as I said, is consulted over terms of reference, choice of investigator, receives the report and makes it public. He acknowledges he has ministerial responsibility, yet his only engagement in his own inquiry is to declare that he expects all ministers to cooperate. Secondly, the CEO of the Department of Prime Minister and Cabinet is a co-commissioner of the inquiry. The CEO draws up the terms of consultation with the Prime Minister, is actively engaged in the inquiry, and yet he is seen as one of the potential suspects. The CEO of DPMC seconds a staffer to the inquiry. The staffer acts, we are told, under the supervision of the investigator, yet exercises personal freedom in visiting parliamentary services on his own initiative at third-tier level, undermining the authority of the General Manager of Parliamentary Services. Fourth, the inquirer adopts the belief that he is free to ask for any information he deems necessary without considering whether its release is constitutionally appropriate. He leaves it to the recipient of the request to determine constitutional propriety. He neither receives nor seeks guidelines on the constitutional and procedural requirements and constraints pertaining to the operation of a ministerial inquiry. He displays a general indifference before the committee to the importance of constitutional constraints. So the main recipient of the request, Parliamentary Services, had serious doubts about releasing information on a minister in journalists' communications, plus the parliamentary access records. Yet he felt compelled not to second-guess the request because of their security implications. The material does not involve issues of national security, but rather domestic politics, which should have heightened and not diminished those concerns. The CEO of the PM's office became engaged. He took it upon himself to, quote, authorise parliamentary services to release data pertaining to ministers and journalists. He did this on a basis that the terms of reference had been made public and that the Prime Minister had made it clear that he expected ministers to cooperate with the inquiry. Despite 3 denials by the head of Parliamentary Services, nevertheless, the Prime Minister's cock crowed and vowed and the data was released. In fact, there's no cause for the CEO of the Prime Minister's office to become involved in the inquiry, being it had been commissioned by the head of DPMC. The co-commissioners clearly harboured uncertainty over the particular status of one minister who had been given the report in the capacity as a coalition party leader, but subsequently was expected to cooperate as a cabinet minister. This blurred further the distinction between his role as a member of the executive, as a government minister, and as a member of the legislature, an MP, and it seemed that nobody seemed to care. No official involved in this whole sorry saga, whether DPMZ or PMO, appears to acknowledge that requests for data pertaining to communication between a minister and a journalist unavoidably means obtaining information about a journalist. Refusal to acknowledge this is strange. They seem bemused by the self-evident fact through the hearings. The Evidence Act 2006 protects the rights of a journalist to privacy over sources, and that is a well-accepted convention at least. So the information platform maintained for ministerial services and parliamentary services became operationally merged in late 2011 for reasons, we are told, of efficiency. This appeared not to bother DPMC, the PMO or the inquirer. The constitutional separation of powers appears not to be a matter of concern for them either. At no stage did the Chief of Parliamentary Services discuss matters of concern with his responsible MP, the Speaker. At no stage did the Speaker judge it necessary to become engaged in decisions pertaining to release of information by the agency under his control. He should have. The press gallery has no contractual relationship with parliamentary services, only with the Speaker. A computer technician contracted from a private company took it upon himself to pass information relating to a journalist directly to the inquirer. Although existing legislation protects the media from releasing such information, no procedural rules were put in place by the inquiry to govern his actions. Sir, the sloppy operation of the inquiry rests on a series of individual misjudgments. The task remains for the committee in its final report to identify ways in which these shortcomings can be rectified. Kia ora.
The Right Honourable Winston Peters.
Mr. Speaker, this is a very sad and sorry saga of a Prime Minister who has acted incompetently